Well, thank you for joining me today. Look forward to talking about special needs trusts in Arizona. I wouldn't be a good lawyer if I didn't do a quick disclaimer. So with that, any information we talk about today does not create or constitute a legal relationship. I am not your attorney unless you've specifically hired me. And so with that, I hope you take a lot away from today, but digest with an ounce of caution. If we haven't had the opportunity to meet, I look forward to meeting you someday. But like I said, my name is Emily. I have been living in Arizona for about 25 years. I grew up in a small town in the Midwest, but came here to attend ASU. Later went to U of A, and the joke is I'll go to NAU next. But with that, I've been practicing law for about 18 years in Arizona, and I feel very fortunate to have been practicing specifically in the area of estate and special needs planning. I'm a member of the Academy of Special Needs Planners, NALA, and as well as the Special Needs Alliance. And so if you're watching this and perhaps you're somewhere other than Arizona, you might get some good takeaways still, but I'd encourage you to use these organizations and primarily the Special Needs Alliance to locate an attorney in your state who understands some of the complexities that we'll be discussing today when it comes to special needs trusts. And then there's a picture of our team, and we practice in Phoenix, just about 10 minutes north of the airport, but thankfully with technology, we're able to serve clients throughout the state of Arizona. So again, if you just joined us, I hope you'll learn some things today. I've opened the Q&A function through Zoom, but I'm going to address questions at the end. And I look forward to chatting with you about some of the things that may come up. So first and foremost, if you're just joining us, there are some resources available for download online, and I've included a QR code for you to reach out there if appropriate. But in the middle, we've got the guide for planning for a loved one with disability, which does open up some discussion points related to special needs trusts like we'll be chatting about today. So you may find it helpful. But with that, let's kick things off. So question of the hour is, what exactly is a special needs trust? And the answer is it's a tool and it depends, but it could be called a lot of different things. And so what we're looking at or understanding is really defining if special needs trust is the umbrella, and we look at and we see SNTs, first party trusts, third party trusts, special treatment trusts, we see that the language gets kind of confusing. So there's a lot of terminology involved, and that I think creates some confusion around what exactly a special needs trust is. But at the end of the day, a special needs trust is a tool that we have in our toolbox, and it's intended to provide financial support for an individual who has a disability and without impacting any government benefits they might be receiving. We're in Arizona, so we're going to talk about Medicaid being ALTCS and access, but we also think about SSI and other programs that may be impacted by the receipt of financial resources. So this type of trust not only helps us preserve government benefits, but it also creates a tool that allows for the management and distribution of assets that are protected in other ways. And so when we know, hey, this is a tool that may be handy to have in our toolbox, or it may be necessary, then we need to further define what that looks like and exactly which type of special needs trust we might need. So to help us get there, what I think kind of works as a good big picture outline, we're going to talk a little bit about very basic estate planning terms and terminology. We're going to talk a little bit about government benefits. You're going to get 10 cents of each. And then we're going to put those together to better understand special needs trusts and the various types. So my goal is to hopefully define some terminology that helps you put together the puzzle of what you may need or want or already have when it comes to planning. When we use terms like trusts, we think of estate planning, and estate planning sounds like a very fancy term, and in fact can be, but it also can be quite straightforward. And so an estate plan is the whole toolbox that we put in place to make sure we have the right team available to help us make decisions on our behalf when we're incapacitated, or ultimately to administer assets through a trust now or in the future when we pass away. So we'll hear terms like powers of attorney, living will, last will, living trust, irrevocable trust. We've got a lot of overlap. So real quickly, let's hit some of those highlights. One of the most important things for you is your healthcare directives. So your healthcare directives are going to be a series of documents that are put in place while you're alive, and if you have capacity to do so. In Arizona, they're usually going to be comprised of a healthcare power of attorney, mental health care power of attorney, living will, HIPAA, DNR, POST. The list goes on. The alphabet soup gets more complicated, but these healthcare directives are pretty straightforward documents that allow us to define who our healthcare team is to make and communicate decisions for us when we're unable to do so. And so this comes up because it could happen we're just under anesthesia and a decision needs to be made. It also could happen if there were an accident or injury or illness that might take us out of commission for a short period of time, or ultimately it could be a long-term disability or dementia diagnosis that allows for and requires somebody to step in and advocate on our behalf. In Arizona, our healthcare directives are also going to be where we share some of our wishes related to autopsy, organ donation, and the like. And so these documents can be quite robust and can be very helpful, not only in creating this team, giving them some instructions about the types of decisions you want made, but ultimately our goal with these are to avoid guardianship. So avoid that if we have the capacity to do so, we can put some simple paperwork in place to make sure that in the future, our friends and family and decision makers don't need to go to court to request a guardianship in order to make these decisions. So super important. Similarly, we're also going to have financial decision-making tools in place. While we're alive, this is primarily going to rely on a financial power of attorney. This document is usually a durable document. That means when you're incapacitated, it also works. Sometimes it's going to be called a property power of attorney or a general. A lot of terminology as you're quickly learning, but the financial power of attorney does a very similar thing. It says, under certain circumstances, this person, professional, lineup of professionals and persons can make financial decisions for me. So doing things like signing tax returns, selling our home, paying bills, and again, might be something that comes up if we're incapacitated or unable to do so. Now, we do need to understand the interplay of this financial power of attorney with our assets. And in order to understand that, it's also very important to make sure we know who might be co-owners on certain assets and who might already have signing authority. We got to put the whole puzzle together and make sure all those tools work together. So real quickly, we got healthcare directives and financial directives. Both are going to be documents that we want to formalize to put our team in place. Our team may not be the same, right? Our healthcare powers of attorney might be great advocates in a complex medical situation, but perhaps they're terrible at balancing a checkbook. And on the other hand, our financial team might be really great at managing investments and making good financial decisions, but not good at working through prescriptions and advocating with doctors and understanding those interesting decisions. Real simply, our guardianship and conservatorship is what we're trying to avoid with those powers of attorney. When we think then about other elements of our estate plan, if we start to look at last wills, these are the ones that always make the TV shows and the movies. These are going to be our documents that say, when I die, here's who I want to be in charge. In Arizona, we're going to call that person a personal representative, but oftentimes we think about the term executor. We're going to potentially nominate a guardian for our minor or incapacitated adult children. So who would step into that guardianship role if you were unable to be the guardian? And then ultimately, it's going to direct the distribution of our estate assets. And so wills can be very simple. They can be very complex. Wills can contain trusts. So if I, for example, have 3 adult children and my daughter, Patricia, is currently receiving government benefits, my will might say, I want my 3 adult children to share in my estate equally, but any share that would go to Patricia shall be held in a special needs trust to preserve her eligibility for government benefits. Now, of course, there's a lot more language that's required and formality, but the idea is my will might contain the terms of a special needs trust. So again, we've got a lot of complexities, language, priority, terminology, but what we're trying to understand is where these different things fit in. So with that will, the one thing to understand is that in Arizona and in most places, wills have to go through a formal process of probate. And so probate means the formal appointment of the personal representative by the court, and then the supervision of their administration of the estate, and a finding that the will was the last will and appropriate. So wills are great tools, but they have some limitations. So with that, one of a common type of trust in Arizona is what we would call a revocable living trust. So when we think about those words, a trust is going to look kind of similar to a will. We're going to say who's in charge. Instead of a personal representative, though, we're going to call them a trustee. We're going to spell out who's able to make different decisions, but who ultimately benefits from the terms of the trust. And then hopefully it's also going to be a tool that allows our trustee to step in, or excuse me, our successor trustee to step in and act without that court supervision and without that probate process. And so a revocable trust means it's a trust that we can change. It can be revoked, it can be amended. Living indicates it's been created while we're alive. And that trust creates that formal relationship between the different players, the trustees and the beneficiaries, as well as all the contingencies and secondary beneficiaries, for example. Trusts do allow us to avoid probate in the event it's properly funded. So we always have to understand the nature of the assets that we own. The ownership and the potential beneficiaries are going to control and supersede. So if we're going to go through the legwork of setting up a family trust or a living trust like we're discussing here, then we need to take that extra step to make sure that our assets are appropriately titled and are mentioned and set up correctly. Now, we could spend days just talking about trusts. In fact, there are semesters at law school dedicated to it. But with that, that tool is going to be really important as a part or an element of an estate plan. But it's also a part of a special needs trust, right? So that formal arrangement of setting up who the trustee is, who the beneficiaries are, and then all of the rules for the different time periods that that trust terms may need to apply. Just like a will, a trust, a revocable living trust, can also include a special needs trust. So I may have said, you know, I'm going to set up a trust. I want to avoid probate. I still want my 3 children to inherit everything when I'm gone, and I still want to make sure that my daughter's benefits are protected. So my revocable living trust might say, when I've passed away, then everything gets divided in 3, and Patricia's share is going to be held in a special needs trust. So you can see where we start to see these special needs trusts come up and how they all fit together. Now, realistically, there's a lot of different and more complex elements of estate planning. I encourage you to go watch one of the other webinars or do more research or call me for a meeting to learn more about the elements. But for basics of estate planning, that gets us to a level where we can start to understand what a special needs trust might start to look like. In order to understand what type of special needs trust we might want or need, we also need to have kind of a basic understanding of benefits. And so benefits are the programs that are set up and run through the government that allow for individuals to get income, health insurance, housing, all sorts of different programs and benefits. Today, we're going to focus primarily and quickly on Social Security and Medicaid, but there are, of course, also other benefits through SNAP and housing and veterans and all sorts of things. So with that, today, that's kind of our goal, is to quickly go through these benefits at a high level. So with Social Security, most of us are familiar with Social Security. We got our first paycheck at our job, and we were disappointed that a large amount of that hourly wage was sent off to Social Security and the other tax agencies. When we are working and earning an income, our Social Security is being sent to purchase us, or essentially, hopefully, make us eligible for benefits based on how much we've paid in. So, our retirement benefits, for example, when we retire and elect to take Social Security, will be tied to our wages earned and our time of work. Same is true with Social Security disability insurance. So, in the event an individual has worked and they've been paying into the Social Security system, and then they're later disabled, which the Social Security Agency defines as unable to be substantially gainfully employed, then at that point, an individual is eligible for SSDI. And Social Security disability insurance is also going to, the value of the monthly payment will depend on how long you've worked and for how much you earned. Now, for some individuals, when they turn 18 or become an adult or even as a minor, the nature of their disability does not allow them to ever start working and earning or contributing to Social Security. And so in that case, we have another program called SSI, Supplemental Security Income. And so SSI is for those individuals who Social Security has determined are unable to be substantially gainfully employed, but who also have not paid into the system. Because they haven't done that, then there's also other financial criteria that's considered. And so when the individual applying for SSI is a minor, then the parents and the income of the family will be counted towards that individual's. And so they'll have to see if they meet financial criteria. But once an individual turns 18, then it's their individual financial resources that are considered. And so for an individual to be eligible for SSI, they have to have less than $2,000 in countable resources. That's a very low number, and it hasn't changed for a long time, but $2,000 or less in order for them to qualify for their SSI benefit. Now, when this individual is eligible for SSI, they'll also be eligible for access or Medicaid health insurance, but this SSI benefit is very sensitive. So it's going to be sensitive to any income being earned by that individual, be offset in a way. It's also sensitive to somebody gifting them money. And it's also very sensitive that if you go over the $2,000, you lose your SSI. Now, what's interesting is with SSI, at some point, you may start to receive a different type of insurance as well, or income. And that's because for certain individuals who are determined disabled before age 22, then when their parent, mom or dad, starts to take or earn based on their Social Security contributions, then if that individual had been determined disabled before age 22, that child's benefit will switch from SSI to a program called Disabled Adult Child Benefits, also called Childhood Disability Benefits. But the idea is that it's being earned based on, the amount of income is based on the parent's contribution record, their paid in amount. And so for some individuals, the timeline looks like they're a child, their parents are working and have resources, so they may not qualify for SSI. They turn 18, they apply for SSI, they're receiving their SSI for 15, 20, 30 years. Their parent turns 67, decides to take Social Security, and now all of a sudden this individual who was on SSI is now earning an income based on their parents' contribution record. And if it was more than their SSI, they're going to have a higher income, and that income is going to mean the SSI has gone away. That Disabled Adult Child Benefits looks and acts a lot more like SSDI, meaning we no longer have the financial requirements, but we do still need to be unable to be substantially gainfully employed. With that, like I said, SSI ties us into the Medicaid access health insurance system. Both SSDI as well as Disabled Adult Child Benefits do allow an individual to be eligible for Medicare after a period of time, even if they're not yet 65. Again, it's a mess. It's kind of a puzzle we got to figure out. But what we need to know is that all of these different programs have different financial criteria, and therefore it's really imperative we understand that we're trying to plan for somebody who might be receiving Social Security. we really need to understand what is the nature of the Social Security they're receiving so we can understand what tool we need to preserve eligibility for that benefit. Now, of course, there's also survivors benefits, caregivers benefits, that sort of thing. So this is not exhaustive of all the types of Social Security, and there's a lot to be considered. I have other webinars that you might want to watch that are recorded and available on our YouTube channel, sharing more about disabled adult child benefits, for example. But there's a lot to learn here. But what we need to really be concerned about is if we have a loved one who's receiving SSI, we have to be extremely careful to make sure they never have more than $2,000 in countable resources. Otherwise, they'll be disqualified from this important income and insurance benefit. If we transition then quickly to another program in Arizona that most of you might be familiar with, we have DDD. So DDD is the Division of Developmental Disabilities. DDD provides support and some other benefits for individuals who have a certain diagnosis. That list of available diagnoses is expanding slowly over the years, but at this point you can see on the screen what those are. Now, DDD eligibility allows the member to have a meeting with a support coordinator, but realistically, when they're meeting with that support coordinator, the coordination of support is tied to the availability of insurance to pay for that different support. And that insurance that is funding the eligible benefits, that is ALTCS. And ALTCS is Arizona Long-Term Care System, and ALTCS is a program of Medicaid in Arizona that allows for individuals, whether they're elderly and physically disabled or developmentally disabled, to receive certain benefits. And just like every other topic we're trying to cover today, we could spend weeks talking about ALTCS, but for today's purposes, we need to understand that an individual who may be getting support through DDD, respite, habilitation hours, attendant care, transportation, housing, the list goes on, that in order to maintain eligibility for those benefits to continue to get those services, they need to meet medical eligibility. So how the nature of their disability is impacting their ability to provide self-care. They need to meet resource eligibility, so financial resource eligibility, which is also for a single individual having less than $2,000 in resources, and then income eligibility. So income eligibility, in fact, for ALTCS is much higher than the $2,000. It's more like closer to $3,000 a month, a little less. And so we have to have all those pieces kept together, medical, financial resources, and income eligibility, to continue to make sure we're receiving services that we've received through DDD support coordinators because of our eligibility to ALTCS. Now, ALTCS also connects us to our Access health insurance system. So if you get ALTCS, you also get Access. And so it's important that we really understand the puzzle and the web that we're weaving between all these different programs. Now, it only gets more complicated if we're later considering HUD, SNAP, veterans benefits, and the like. But these are our two big programs that we need to be really careful with. And so if we have a loved one who's receiving SSI or ALTCS, it's imperative that we understand how the receipt of additional financial resources might disqualify them from this income and support, as well as insurance. So protecting these benefits is part of what we're doing, right? And so the idea is one of the ways we can protect these benefits is through the use of a special needs trust. So if we go back to that original definition, we understand that this trust, a special needs trust, is a tool designed to provide financial support to individuals without impacting their eligibility for programs like Access, ALTCS, and SSI. The type of trust we need will depend on a lot of different factors, but primarily we're going to be looking at two big questions. Number one, where is the money coming from? And number two, what are we trying to protect? So the money, and knowing where or understanding where it's coming from, is really important. And that's because we have two big buckets. The money can either already belong to the individual receiving benefits, or it might belong to a parent or a grandparent or somebody else who wants to provide for this individual but hasn't yet. And so we need to really understand what we're talking about in order to understand which tool we're trying to plan for. Now you see on the screen, and depending on the size of your screen, you may or may not be able to see the details, but kind of a diagram. And off to the side, we can see a house and some different types of accounts and financial resources. Up top, we can see an estate plan, and then right below that, we can see third-party trusts, both standalone and subtrusts. And then down towards the bottom, we can see able accounts and first-party trusts. And so if we take that person in the middle of the diagram, and we'll just call him Patricia, since that's the name I picked earlier. And Patricia is receiving SSI or ALTCS. And now all of a sudden, Patricia has more than $2,000. If that money already belongs to her, we're going to have a different series of solutions than if mom and dad want to provide for Patricia and they have an opportunity to plan. And so that's what we're going to work on, is figuring out what that looks like. So we're going to go through the first scenario first, and that is a first party special needs trust. That means Patricia earned too much money and saved it, received a settlement or an outcome of a lawsuit, or somebody didn't do estate planning and left her an inheritance. All of a sudden, Patricia's great aunt passed away, and she thought she was being very generous and she wanted to take care of Patricia. So she said, Patricia will be the beneficiary of my life insurance. Well, at that stage, then Patricia now has $100,000. And boy, that's $98,001 too much. And Patricia's going to lose her SSI and her ALTCS benefits if we don't come up with a way to protect and manage that money. And so one opportunity we have is what's called a first party special needs trust. Now, because Patricia already has legal ownership or is entitled to those assets, we are limited in our ability to protect and manage this money. One option we have is to spend the money in the same month it's received. It's hard to spend $100,000, and typically we want that money to be available over a longer period of time. We could potentially, and we'll talk a little bit about ABLE accounts, we could use an ABLE account, which allows us to preserve some eligibility for benefits. However, ABLE accounts are limited on an annual basis to a certain amount. In 2025, that amount is $19,000 a year. So that's not going to solve our problem when it comes to this life insurance. So now we're looking at what's called a first party special needs trust. Now these trusts, because they're planning and preparing for funds that already belong to Patricia, have a ton of rules. And this is the shortest list of rules and not exhaustive by any means. But this type of trust must be irrevocable. It must be a type of trust that cannot be changed in the future. It has to be established and funded before Patricia's 65. So if Patricia's over 65, we're not going to have a first party trust as an available tool. It can only be funded with assets belonging to the beneficiary. So only Patricia's assets are going to go in there. There's going to be a lot of oversight. So SSI and ALTCS are going to look very closely at these trusts. Sometimes we have to involve the court. So if Patricia is under a guardianship and doesn't have capacity to plan for this $100,000, we may need the court to be involved through the use of a guardianship or conservatorship to set up and fund the trust. And most importantly, this trust is a sole benefit trust, and at Patricia's, usually her death, but at the termination of the trust, the state that's provided Medicaid services has a right to reimbursement for those claims. And so if Patricia's been receiving ALTCS for 20 years, she receives this $100,000. We can't use an ABLE account. We don't want to spend it. We're going to have to set up a first party trust. We're going to have to set up this irrevocable trust that can't be changed, that has to be managed by somebody other than Patricia. She cannot be her own trustee. And the use of these funds are going to be strictly overseen and must meet very certain criteria. So for example, ALTCS, this trust will have to be disclosed. It'll have to go through thorough legal review. The benefits and the use of the funds are governed by what ALTCS has approved prior to use. So we have to get approval of our anticipated disbursements as well as disbursements that come up suddenly. We have to get pre-approval from ALTCS. And SSI is going to have its own series of review and eligibility review of the trust and the funding of the trust as well. So these trusts are really tricky. And depending on the nature of the benefits being received, we have to understand how strict the oversight will be. And they're also for the sole benefit of Patricia. So that gets a little tricky in the event Patricia is living with roommates or family members. How do we make sure that the benefit from the trust is for her benefit alone, not the household, not her friends, can't be used for gifts, things like that. So first party trusts are really tricky. Now, in contrary, excuse me, the other type of trust we could be considering or contemplating is when we have an opportunity to plan. So let's go back in time and pretend we're Patricia's aunt. And she set up a meeting with me and she said, I really want to provide for Patricia. My niece has a disability that prevents her from being able to work. She's receiving SSI and she's also getting services through DDD and ALTCS. And therefore, I want to make sure this life insurance is available for her, but I want to make sure it doesn't disqualify her benefits. So in that case, because the money does not yet belong to Patricia, her aunt is going to be able to set up a third-party special needs trust. And sometimes we call this a supplemental care trust or a supplemental needs trust. Again, the language isn't as important as the technicalities of the trust, but this type of trust can only be funded with assets that do not belong to Patricia. So this is the type of trust that parents, grandparents, aunts, loved ones might set up for individuals that they want to leave assets to allow somebody to benefit from this money without causing some of the havoc we talked about with the first party trusts. So these trusts are funded with assets that belong to anyone other than the beneficiary. They do not disrupt public benefits as long as they're properly structured, set up, disclosed, funded, and used. And the nice part is that when the primary beneficiary, Patricia in this case, is done using the funds, the original trust maker can designate where the remaining assets go. So Patricia's aunt might say this is available for Patricia for the rest of her life, but should Patricia pass away, any funds remaining don't go to the state. Instead, they go to Patricia's other two siblings or Patricia's nieces and nephews. Sometimes we can use charities and the like. Now, these trusts, again, Patricia cannot be the trustee. She can't manage this, and she can't have rights to demand access to the money. But there are a lot of other ways in which this type of trust can be flexible. So when it's created, it might be revocable or irrevocable. That'll depend on the goals of the trust maker and what they're intending to do with it. This trust can have a lot more flexibility in terms of some of the remainder beneficiaries, the structure, all of that. And this trust too must be disclosed to ALTCS and Social Security when it's funded. However, largely once it's funded and it's been established that this trust was appropriately set up and funded, the agencies are not going to have the strict level of oversight that they do over the first party trusts. Typically, this is also helping us stay out of court. So if Patricia is incapacitated, we don't have to go set up a conservatorship. We don't have the court supervision, all of the like. So you can see that if we have a choice, this is going to be a much more flexible way to do this. But in order to need or use this type of trust, we need to have planned in advance. And so helping understand what we're looking at and what we need to do will help us understand what we might want to set up. So with that, I mentioned briefly ABLE accounts. ABLE accounts can in fact hold first party money, so money that belongs to the beneficiary already, and third party money. However, what can go into the ABLE account is restricted. And so, oops, I need to change my slide. This says 18,000, but it's in 2025, it's 19,000. But that doesn't mean Patricia's aunt can set up 19,000, mom and dad can set up 9. It means in total for that year, up to $19,000 can be funded. Now there's a slight exception. If Patricia's working, she might be able to put a little bit more extra money in there, but in large part, where our hands are kind of tied. There may also be a maximum funded benefit amount for an ABLE account, depending on if Patricia's receiving SSI. And ABLE accounts do allow for use for certain types of qualified disability expenses. Kind of informally, I would say the flexibility of an ABLE account fits somewhere between a first and a third party trust. The funds, again, so long as we've met all these rules and they're being used correctly, should not disrupt government benefits. Right now, in order to establish an ABLE account, there does have to be a determination of disability before 26. That has been approved to change and go up to 46, which I think it does somewhat soon. It's kind of an odd law passage because it was delayed, but that tool. And then the other thing I will say is that at least right now in Arizona Medicaid agencies do still have the ability to collect the remaining benefits from an ABLE account when the beneficiary passes. So again, if we're trying to avoid state payback, we don't want to use this as a way to preserve benefits for when the beneficiary passes away, as the state may still be able to make a claim. So with that, hopefully we're starting to get the big picture. I want to kind of go over a couple common special needs trust myths. So first and foremost, a lot of people think special needs trusts or estate planning in general is only necessary for the wealthy. The hard part is that with a lot of our crucial and critical government benefits, we have a resource limit of $2,000, which means that can pretty easily be disrupted. So if a parent or a grandparent has a life insurance policy through their employer, retirement benefits, a home, those assets need to be planned for if they want to leave them to a beneficiary who is receiving benefits. So it's not one size fits all. The other special needs trust myth is that they will disqualify the beneficiary from receiving government benefits. Now, of course, I do have a couple caveats to that. Is no, a special needs trust is intended not to disrupt government benefits. However, that means that we have to have the right type of special needs trust. It needs to be created correctly, it needs to be funded correctly, and it needs to be used correctly. So yes, from time to time, a special needs trust will result in disqualifying from benefits if it's misused, misset up, or not done correctly from the start. So again, that's just why it's really important to work with an attorney who has an understanding of all these different rules and complexities. But in general, these types of trusts are intended to preserve those government benefits. And then the big myth, of course, is a lot of people still believe that all special needs trusts have the payback requirement to the state. And that's not in fact true. First party trusts and ABLE accounts do or could be claimed by the state. However, a third party trust can be left to a remainder beneficiary, somebody other than the state. So important to know and distinguish, and important to know what type of trust you have so we make sure that doesn't happen incorrectly. So if we're reviewing, we kind of zoom out again and we look at Patricia. Let's pretend that's Patricia in the middle there. And she's receiving SSI, ALTCS, or DDD. We want to preserve those benefits. And Patricia all of a sudden has too much money because they've received an inheritance, a settlement, just saved too much money accidentally, whatever the like. Their tools for preserving that are spend it in a month. Well, that's really ties our hands and not usually something we want to try to do. If that amount of money is less than $19,000, potentially they can use an ABLE account to preserve eligibility for benefits by moving that money into an ABLE account on an appropriate timeline. Or we're going to have to use that first party special needs trust in order to continue receiving those government benefits. That first party special needs trust is going to have a lot of rules. It has to be established and funded under the age of 65, and it's going to have that payback. Therefore, we're going to have to get permission for how things are used, depending on the benefits we receive. Alternatively, if we at this point have an opportunity to plan, and what we're trying to do is set up a trust that allows for Patricia to have extra resources and funds available for when family members are deceased, or if they just want to set it up now to have this flexibility. If somebody else, anybody else other than Patricia, parents, grandparents, aunts, uncles, best friends, want to set up a third-party trust and move assets into that trust, a lot of times are commonly done through their estate plan, then we have two different options there. So the third-party trust can be either a standalone trust. We might create the Patricia Trust June 2025 that exists. We can go open accounts, we can move things in there. Or mom and dad, grandma, grandpa might again write that will or that trust that says when they pass, then any assets that go to Patricia then go into the third-party trust that's created at that time. So we have different ways to do that. It's just important, again, as you're planning, to understand what a preference is. Now, if we have a whole bunch of people, maybe Patricia's got a lot of friends and family that want to support her and want to fund a special needs trust, it's nice to have one that everybody can contribute to if they approve the details of that trust. And so again, we might do a standalone trust if grandma and grandpa, mom and dad, and aunt and uncle all want to provide to the same trust for Patricia's benefit. Alternatively, the third-party trust works great too if we're just hoping to have this tool or resource available in the future when mom and dad, grandma and grandpa are gone. So the big picture is, again, if we go back to it, if we have an opportunity to plan, mom, dad, grandma, grandpa, we want to say these assets should be funded into an estate plan so that through that estate plan, either now or in the future, we can fund that third-party trust, whether it's a standalone trust or a subtrust. If we don't have that opportunity to plan and we understand that the individual receiving benefits already has access to too much funds or resources, we want to understand what's the best plan for them. Is it a combination of an ABLE account, a first party trust, and spend down? Potentially, but we just really need to come up with a plan so that in the interim we don't lose eligibility for services. Sometimes that might also include the court, so we've got different timelines to figure out what that looks like, but it can be more complicated, but it's still an available option. And in that other scenario where somebody perhaps later in life has their own personal resources and then is very badly injured or has a disease that results in disability, sometimes we can use first party trusts in that area as well to try to preserve some of those assets or savings in a way that will be available. So hopefully that's helpful to kind of, again, zoom out and really consider what kind of special needs trust you need for your situation. Like I mentioned, the Q&A function is open. If you're attending this webinar live, feel free to chat and put something in there for me in the next minute or two. Otherwise, as I already shared, there are additional resources available for download. There's other webinars available on our website. You can follow us on YouTube. There's a lot of great things you can do to continue learning about special needs trusts. And then ultimately, I encourage you to work with an attorney who's in your state, who practices and spends a lot of time with special needs trusts so they know what they're doing. Like I said in the beginning, Special Needs Alliance, Academy of Special Needs Planners, some of these other agencies are great resources to find somebody in your neck of the woods. And of course, if you're in Arizona, I'd be always happy to meet with you, and you can schedule a consultation through our website or by calling us. Once again, I'll make a call for questions. There is a Q&A function if you can type it in. If not, I do see somebody has their hand raised, but I'm going to go ahead and quickly say thank you, and I'm going to end the recording and encourage you to reach out if you'd like.